that I will be making is allowed, any other recording is not allowed and may constitute a contempt of court.
Appealing the matter of Mirchandani and the Lord Chancellor.
Yes. Good morning, Mr. Friston.
Good morning. May it please your Lordships, my name is Friston. I'm here on behalf of the prosecutor, who is the appellant in this matter, and my learned friend, Mr. Cohen, appears on behalf of the Lord Chancellor, who is the respondent in this matter. My Lords, this is my appeal against the decision of Mrs. Justice Jefford made on the 1st of August 2019, that order setting aside an order that the prosecutor be entitled to certain costs out of central funds, and permission that was granted by Mrs. Justice Jefford on the same day. 2 points of statutory interpretation arise, both of which concern Section 17 of the Prosecution of Offences Act 1985, and they are the meaning of the words proceedings in respect of offence within subsection 17(1)(a) of that Act, and in particular whether those words should be read narrowly so as to exclude enforcement confiscation proceedings in the High Court. And secondly, round 2, the meaning of the word expenses in that same subsection, and in particular whether that word is to be interpreted in such a way as to include the costs of an opponent that a prosecutor may be ordered to pay. My Lords, with your permission, I propose to divide my submissions into 4 parts. I'm going to begin by briefly summarising the facts. Then I will deal with jurisdiction, this being a point that Lord Justice Davis referred to in an email to Council yesterday morning. Then I will deal with round 1 and then round 2.
Mr. Friston, so far as the facts are concerned, please remember that we will all have read the skeleton arguments and the judgments below.
I'm very grateful. In that case, then, I will not trouble the court with the facts. Yesterday morning, Lord Justice Davis helpfully sent Council a message by way of an email that this court would like Council to confirm that they see no jurisdictional issue arising out of the Court of Appeal hearing this matter, and this, of course, being a reference to Section 18 of the Senior Courts Act 1981.
Sorry, Mr. Cohen, while you're waiting to address this, could you turn off your video? It just helps with the bandwidth and everything else. If you could turn that off and your microphone. If you wish to intervene, obviously turn them on again. Thank you very much. I'm so sorry, Mr. Friston, do carry on.
Thank you. Council have produced a supplemental authorities bundle, which is entitled Authorities Bundle Relating to Jurisdiction. And that contains...
Yes, Dr. Friston, I wasn't trying to suggest I had any great concern, but what I did want to be sure about is you considered the point, because some of your arguments possibly brought that into play. I wasn't trying to indicate that I had any very great concern, just enough concern to want you to confirm the position.
My Lord, I'm very grateful for that clarification. Yes, the point has been considered by both Council, where both of the view that the authority of government of the United States of America versus Montgomery 2001 Weekly Reports 196, and in particular at paragraphs 21 to 23, say that we are in the correct court. And during the course of my submissions, I will be explaining why I say that the test as to whether or not proceedings are a criminal cause or matter is a different test to that which is in section 17(1).
Yes, well, I think also the potential width of Belhage, which might have been a problem, I think has been perhaps reduced by the subsequent decision in McGuinness, which I think probably removes a concern that otherwise one might have had.
Indeed, yes, indeed. But in any event, insofar as jurisdiction is concerned, even if not guided or didn't have the guidance of the House of Lords in the Montgomery case, the position of the appellant would have been that this would in any event have been a collateral matter of the type referred to at paragraph 75 of McGuinness, which I probably don't need to take the court to, but in essence this wasn't an issue arising out of the prosecution itself. It was a collateral matter arising between the arising out of a dispute between the prosecutor and the Lord Chancellor's Department as a funder. So unless the court wishes me to address the issue of jurisdiction any further, I will move on to ground one of my appeal.
Thank you.
If I could ask the court please to turn to the authorities bundle, by which I mean the main authorities bundle, and to page 17 thereof.
Have you got a tab number?
Yes, it's in tab. It's in tab 3. Sorry, tab 2.
Thank you.
This is section 17 of the 1985 Act, and it's subsection 1, to which I draw the court's attention. Subject to subsections 2 and 2A below, the court may, A, in any proceedings in respect of any indictable offence, and B, in any proceedings before the Divisional Court of the Queen's Bench Division or the Supreme Court in respect of a summary offence, order the payment out of central funds of such amount as the court considers reasonably sufficient to compensate the prosecutor for any expenses properly incurred by him in the proceedings. And this section continues at 2A, where the court considers that there are circumstances that make it inappropriate for the prosecution to recover the full amount mentioned in subsection 1, an order under this section must be made for the payment out of central funds or such lesser amount as the court considers just and reasonable. And then subsection 2B, when making an order under this section, the court must fix the amount to be paid out of central funds in the order if it considers it appropriate to do so, and A, the prosecutor agrees the amount, or B, subsection 2A applies. And then 2C, where the court does not fix the amount to be paid out of central funds in the order, A, it must describe in the order any reduction required under subsection 2A, and B, the amount must be fixed by means of a determination made by or on behalf of the Lord Chancellor in accordance with procedures specified in regulations made by the Lord Chancellor. And the question...
Could you just, what's the rationale for subsection 2, which precludes public authorities from benefiting? What's the rationale for that?
I haven't looked into that matter, but I would imagine that the rationale would be that these are monies coming out of public funds, and therefore, if the prosecutor is a public authority or a person acting on behalf of a public authority, there would be other means by which they may be funded.
Thank you.
Isn't it also the case that this provision is to deal with the issues of private prosecutors? So that's really what its ambit is, partly at any rate.
Indeed, that is correct. And of course, this Act, in addition to creating this provision relating to prosecution costs also created the CPS. So certainly public authorities who prosecute in general would be covered by other provisions, but there would be some public authorities that may not be. I understand that the Financial Conduct Authority is one such authority that may act as a private prosecutor and may rely on subsection 17 in order to secure its costs. But as I say, I've not looked into that, and so I can't be sure on that point. But in any event, just returning to subsection 1, the question is whether or not these proceedings fell within the ambit of proceedings in respect of an indictable offence. And in that regard, I now turn to the nature of the proceedings themselves. And if I could ask the court please to turn to page 110 of the authorities bundle, which is, I think, at tab 5. This is Order 115 of the Rules of the Supreme Court, which has been preserved by way of Schedule 1 of the Civil Procedure Rules. And this governs, or at least provides the adjectival law that governs the procedure of any claim or application that is made under Part 6 of the Criminal Justice Act 1988. But I just want to draw the court's attention that these provisions govern a number of other similar provisions. In fact, the rules were originally made on the 12th of January 1987. These rules, the RSC Order 115, on the 12th of January 1987, to complement the Drug Trafficking Offences Act. And that act, in due course, was replaced by the Drug Trafficking Act 1994, which was a consolidating act. But RSC Order 115 has been pressed into service in many other respects. Obviously, it's been pressed into service insofar as Part 6 of the Criminal Justice Act is concerned. That is the act with which we are concerned today. In addition to that, it's been pressed into service insofar as the Prevention of Terrorism, Temporary Provisions Act 1989, subsequently replaced by the Terrorism Act 2000, the Criminal Justice International Cooperation Act 1990, and the International Criminal Court Act 2001. But it is also important to note that this legislation has now largely been replaced by the Proceeds of Crime Act. When contrasted with all of the legislation that it replaces, that's all of the cases I have just mentioned, the Proceeds of Crime Act 2002 gives a far greater role to the Crown Court than to the High Court. Under the 2002 Act, applications for restraint or the appointment of a restraint order or for the appointment of a receiver, which would previously have been made to the High Court under Part 6 of the 1988 Act, would instead be made to the Crown Court. And just by way of example, if I could ask the courts to turn to page 107 of the authorities bundle, is, I think, 4 of the paper bundle. This is section 50 of the Proceeds of Crime Act, and it reads, this section applies if a confiscation order is made, is not satisfied, and is not subject to appeal on the application of the prosecutor the Crown Court may by order appoint a receiver in respect of the legalising of property. That's just one example of many. But in essence, all of the powers that I'll be referring to today under the 1988 Act would now be exercised, and to the extent that they still exist, would now be exercised under the Proceeds of Crime Act 2002 by way of the High Court, rather than by the Crown Court, rather than by the High Court.
If the Crown Court exercise powers under Section 50 and Section 51 of POCA, is that a criminal proceeding?
In my submission,
Or is it a Crown Court acting in some way civilly? It's like a concept, but would you say it is a criminal proceeding?
in my submission, yes, it would be a criminal proceeding and be caught under Section 17 of the 1985 Act. And I say it would be very curious if it were otherwise, because it's part of the criminal process. Now, returning to the 1988 Act, the provisions of the 1988 Act, for the sake of completeness, I should also add also of the Drug Trafficking Act 1994, continue to apply that any of the criminal acts were carried out before the 24th of March 2003. As I've mentioned, in those cases, restraint and receivership applications continue to be made to the High Court under rules of the Supreme Court Order 115. And I've also to say that
this case perhaps doesn't have any very great implications, because there must be precious few cases where the Criminal Justice Act still is biting.
One would imagine that they would be somewhat of a rarity. Yes, I would accept that. I would accept that point. Yes. That being said, it is a matter of some importance to those people who are involved in such litigation, not least because the tail end of such cases is likely to relate to larger cases and therefore significantly large amounts of money, as on the facts of this case. Having just set out the genesis of these various schemes, it can be seen that the various schemes of confiscation had their origins in the management of highly profitable crime, namely drug trafficking. And Part 6 of the 1988 Act extended this to other profitable crimes, and by its very nature, highly profitable crime would lead to dissipation of ill-gained assets. And as such, there may be a need both to preserve assets and to adjudicate on the ownership of assets, and that is partly a reason why these proceedings tend to have a civil flavour to them. If I could now ask the court to turn to page 30 of the authorities bundle, that being tab 3. What I'm going to do is to run through very briefly Part 6 of the Criminal Justice Acts, just to give the court a flavour of the way in which it operates. And in that regard, I Section 71 itself, which says that the Crown Courts or the Magistrates' Courts may make what are known as confiscation orders. And for present purposes, one doesn't need to know the circumstances in which a confiscation order may be made, but I would like to draw the Court's attention to Section 71, subsection 6, page 31. This deals with the amount of a confiscation order, and it reads as follows. Subject to subsection 1c above, the sum which an order made by the court under this section requires an offender to pay must be at least the minimum amount, but must not exceed the benefit in respect of which it is made, amount appearing to the court to the amount that might be realised at the time that the order is made. So, in essence, the court will, when making a confiscation order, will carry out a two-stage process. Firstly, it will try to work out the benefits of any crime, and that will be the upper limit. But then it will also form a view as to the amounts that may actually be realised, and that will form a further limit, and the court then makes an order for whichever is the less. Key to the application of confiscation orders is an understanding of the statutory expression realisable property. And this is the only type of property which may be subject to a restraint order or over which a receiver may be appointed. And if I could ask the court please to turn to page 39 of the bundle. You will find section 74 of the 1988 Act, and it defines realisable property in these terms. In this part of this Act, realisable property means, subject to subsection 2 below, any property held by the defendant and any property held by a person to whom the defendant has directly or indirectly made a gift caught by this part of the Act. And whilst it's not an expression that appears in this iteration of the scheme of compensation, such gifts are generally referred to as being tainted gifts, and that in fact was the phrase that Mr. Justice Jefford used in her judgment. So, realisable property will not simply include those monies that are actually held by a defendant, but also may include any property held by a person to whom the defendant has made a gift. And in view of that, there is a need to adjudicate on the rights of third parties, and generally the rights of third parties are paramount. The establishment of those interests is determined in accordance with conventional property law principles, and these are essentially civil matters in the sense that they may involve the determination of proprietorial rights. As such, under the 1988 Act, these sporting powers were exercised by the High Court by way of the Part 8 procedure.
Can I ask you this, under POCA, where these matters now take place in the Crown Court, is that equally the case in relation to third-party transactions? The Crown Court will apply ordinary property laws?
As I understand matters, yes, although I have to confess that I am primarily a cost practitioner rather than a criminal practitioner, so I can't speak with any authority on that point, but my reading of the matter is the
answer is that if a dispute is, for example, raised as to whether or not someone has a beneficial interest in property in the name of the criminal defendant, then Crown Court has to apply ordinary property and equity law principles.
I'm very grateful.
Well, all I can say to that is good luck to them.
Indeed.
There was some talk about getting Chancery Division judges to do confiscation cases, but I don't think there's much enthusiasm.
Thank you.
So certainly, whichever court these proceedings take place in, it is very much on the borderlands between civil law and criminal law. And I'll be coming to that a little later on in my submissions. But if I may, I just want to carry on going through the structure of Part 6 of the Act. As I say, applications under the 1988 Act are made to a single judge of the Administrative Court. And the High Court has a number of powers that could usefully refer to the supporting powers. And the first two I would refer to are restraint order and charging orders, and they go to the preservation of assets. So perhaps if I could ask the court please to turn to page 77 of the bundle. I do apologise, 51. I do apologise. I meant section 77, which is at page 51. This section is entitled Restraint Orders, and I'm not going to read it out, but I just want to draw the court's attention to one or two points. As you can imagine, a restraint order may be made for the purposes of preserving assets, and such an order may be made even before somebody is convicted, and as I understand matters, may even be made before a prosecution has been made. But I would like the courts just to note, and this is going to be a recurring theme, that at paragraph 77.5, the following says, a restraint order may be made only on application by the prosecutor. And I pause here to say that with one exception, which I'll come to a little later on, the prosecutor is an absolutely central player, central actor, insofar as all of these supporting powers are concerned. And as you can see from section 8, subsection 8 of section 77, the High Court has the power to appoint a receiver. And that type of receiver is, as I understand matters, known as a management receiver. So their purpose would be to preserve the assets pending an order being made, or to avoid dissipation. So that's section 77. And I move on to section 78, which is at page 54. And this section deals with charging orders in respect of land and securities and the like. Again, I just draw the court's attention to paragraph or subsection 3. Again, may only be made on application by the prosecutor. So once again, the prosecutor is an absolutely central actor in this matter. And I'd also draw the court's attention to subsection 2, which reads, for the purposes of this Act, a charging order is made under this section imposing on any such property as may be specified in the order a charge for securing payment of money to the Crown. Again, that is a recurring theme. All of the benefits or potential benefits of all of the supporting powers that we will find in section in part 6 of the 1988 Act essentially go to benefits that would ultimately inure to the Crown. So I make the point again that not only is the prosecutor a central very much in that capacity, and they're acting for the purposes of benefiting the Crown.
Mr. Dr. Friston, you referred to that. It might be helpful to look at the order that was made in this case. In other words, the actual order made by Judge Hone. I don't know if you've got the bundle reference for it.
Yes, I've just
try, because the order that was made was for confiscation and compensation. With have you got the bundle reference for that?
Yes, the order was, 1 second. It's in the supplementary bundle at page 55, which I'm not sure if the supplementary bundle is tabbed, but if it is tabbed, it is likely to be at tab 3, but it's at page 55.
Tab 5, I think.
Oh, thank you.
Looking at the order that was made, we can see how it's structured by the court in this case. That we have a sort of interleaving of confiscation and compensation. But it's a confiscation order of 20 odd million, and then a compensation order of 18 million, and then 4 monies actually realised under confiscation order should first be paid to satisfy the compensation orders. I just wondered about the mechanics of how that would work in this case. Assume for the moment that sum, I think some sums were realised by way of settlement. What are the actual mechanics of it?
As I understand matters, the monies would have been recovered firstly for the benefit of the Crown, so the receiver would have been appointed, and the receiver would have realised whatever assets were available. They would have been paid to the Crown, and in doing so, the receiver would have been entitled to have taken payment of his or her fees in this case. And then once the monies have been paid to the Crown, those monies to the extent that they were compensation, would then be paid as being compensation to the prosecutor. And I fully accept that may or may not be a factor that the court may be able to take into account for the purposes of exercising discretion as to whether to make an award out of central funds. But here, this appeal is concerned only with jurisdiction.
Well, speaking for myself, I don't find the suggestion the prosecutor is acting solely in the interest of the Crown very convincing. I mean, insofar as there is a compensation order, then one isn't doing it. It's only insofar as the money recovered exceeds the compensation to be paid, and pursuant to the compensation order, that anything goes to the Crown. But that's just perfectly consistent with practice and law across both civil and criminal jurisdictions, which is if there's nobody else entitled to the money, the Crown gets it. But that's not to say that people are acting primarily for the interests of the Crown?
Well, primarily they are in the sense that the money will be paid, will be paid, will be inured to the Crown. But I fully accept that, as I understand that, the mechanics of this, and I'll be corrected if I'm wrong, but the mechanics of this are that the receiver pays the money to the court, and then the court pays any compensation out to the to any person who is entitled to compensation. And I fully accept that that although primarily that interest is one that is the Crown's, the prosecutor may also have a personal interest. But I have to stress, this appeal relates to jurisdiction, not to the exercise of discretion, and therefore, in my submission, one has to look at what may happen in a case where there is no compensation. Because if there's no compensation order, then a prosecutor would be acting solely for the benefit of the Crown. And the question is whether or not the jurisdiction to make an award out of central funds exists.
It mustn't also be forgotten that you could possibly usefully abandon the word private from the word prosecution. Prosecution is a prosecution which would always have a public element in it. Equally, there is a public benefit to depriving criminals of the fruits of their crime, which is after all the rationale for this whole suite of legislation. And how it's, I can put it rather bluntly, how it's then divided up afterwards might be said to be a subsidiary question. But ultimately, this is, I mean, you could transpose these facts, but minus the word private, to any drug trafficking or other type of confiscation proceedings.
Indeed, and a little later on, I will be addressing the court as to why I say that the exercise of powers under Part 6 of the 1988 Act can be said to be part of the criminal process. And I'm making exactly the point that your lordships have just made, and that is that there is significant public benefit in depriving habitual criminals engaging in highly profitable crime of the funds to carry out further crimes. But if I may just return to just giving an overview of Part 6 of the 1988 Act. I've dealt with charging orders. I now move on to orders that go not to the preservation of assets, but to the realisation of assets. And if I could ask the courts to turn to page 56, we'll find the section under which this particular application was made, this being section 80. And in this regard, I'd ask the court to note that this section will apply, under subsection 1, will apply where a confiscation order is made, little a, where the proceedings in question have not, the application in question has not been concluded, and the order or variation is not subject to appeal. So these powers can only be made where there are extant proceedings, as it were. And subsection 2, again, the court may appoint a receiver in respect of realisable property. And I'm sorry to sound like a broken record on the point, but you can see again in subsection 1 that the application may be made by the prosecutor. So once again, the prosecutor is a central actor insofar as these provisions are concerned. An enforcer who is appointed under this section is, as I understand matters, normally referred to as being an enforcement receiver, so that their task will be to recover any and realise any assets, and that may involve examining the rights of third parties. So you can see at subsection 8, parentheses 8, that the court is required to give reasonable opportunity to anybody who may be affected by any discharge that it is likely to make insofar as property is concerned. And then if I could ask the court to turn to section 81, which is on page 57. This is the application of proceeds of realisation and other sums, and this essentially is a waterfall of preferences. And as you can see, I'm not going to take the court through this in any detail, but as you can see, there's provision there made for payment of any insolvency practitioner, and various other rights. So this is the way in which the monies are dealt with and divided up, as it were. And then, if I can ask the court to turn to page 59. I invite the court's attention to section 83. This is variation of confiscation orders. This is one of the exceptions, because this is an order or an order that may be made on application by someone other than the prosecutor. And indeed it may be made, as you can see from section 83(1)(a), by the defendant himself. It may also be made by a receiver. And the way in which this works is that if the court is satisfied on application by the defendant or by a receiver that the realisable property is inadequate for payment of the amount that is outstanding, the court will issue a certificate. It's known as a certificate of inadequacy. And armed with that certificate, the defendant may then return to the Crown Court and ask the Crown Court to vary the original order. And you recall that the way in which the Crown Court makes the original order is it works out the amount that has, or works out the amount of potential benefit of the proceeds of any crime, but then it seeks to limit it to an amount that may actually be realised. So under this section, the defendant, if they're armed with a certificate of inadequacy, can return to the court and ask for the order to be varied. And importantly, in my respectful submission, the defendant may not only ask for the order, the amount to be varied, and this is subsection 4, but may also ask the court to change the term of imprisonment or detention fixed under subsection 2 of Section 139 of the Powers in Criminal Court Sentencing Act 2002 in respect of the amount to be recovered under a shorter period of time determined in accordance with that section in respect of a lesser amount. So that section is, of that Act, is one that imposes terms of imprisonment for unpaid fines. So, in essence, the procedure could be, on application by a defendant, a certificate of inadequacy is obtained, and as a result of that certificate of inadequacy being obtained, prison, or the time spent in prison by the defendant for non-payment of any monies may be reduced. And this, I say, just highlights the fact that whilst these supporting powers are referred to as being enforcement proceedings, and whilst they certainly have a civil character, and whilst they undoubtedly are governed by civil adjectival law, they are an integral part of the criminal justice process.
So can you just tell what do you mean by adjectival law?
Procedural law.
Thank you.
If I may now ask the court, sorry, just for the sake of actually, no, I will. I think I've taken the court through enough of the provisions in Part 6 of the 1988 Act. So, in my respectful submission, the exercise of all of these supporting powers, be they ones intended to preserve property or intended to realise assets, are part of the criminal process, notwithstanding the fact that civil procedural law applies. And this is for the following reasons. Firstly, save for a variation under Section 83 of the 1988 Act, where any part A claim could only be made by the prosecutor, who is a central actor, and that person is a Minister of Justice and a person who is very far from being an ordinary citizen. The fact that in some circumstances that person may also have a personal interest in the matter does not detract from either of those things. Secondly, where an application is made under Section 83, it may result in the confiscation order being varied at the term of imprisonment under Section 139(2) of the Powers of the Criminal Court Sentencing Act 2000 also being varied. Again, that strongly implies that the powers that are being exercised by the High Court, whilst they are civil insofar as procedural law is concerned, are part of the criminal process. Thirdly, any Part A claim that is made for the purposes of preserving or obtaining monies would inure to the Crown, at least initially, rather than to the individual. Fourthly, such an application could only be made if there were extant criminal proceedings, and I've already taken the court to those provisions. Proceedings are not concluded until the confiscation order is paid, or no confiscation order is made. And in that regard, I just draw your attention to the definitions given at Section 102, subparagraph 12 of the Act, which confirm that proceedings are not concluded until the confiscation order is paid or no confiscation order is made. Next, the application notice or claim form must be served on the defendant. And in that regard, if I could ask you to turn to tab 5 of the authorities bundle and to page 112 thereof. You find rules of the Supreme Court, Order 115, Rule 7.2a, the application notice or claim form, as the case may be, shall be served with evidence in support not less than 7 days before the date fixed for the hearing of the application of claim form on the defendant and any other person holding interest in the life or property. It is not simply a matter of these proceedings being between the prosecutor and third parties. The defendant is a party. And then finally, any application or Part 8 claim must be entitled in the name in the matter of the defendant. And we'll find that on page 110 of this bundle, 2 pages up, at Rule 2a, which reads that an application made in accordance with CPR Part 23 or a claim form issued in relation to proceedings under this part of this order shall be entitled in the matter of the defendant, naming him, and in the matter of the Act, and all subsequent documents in the matter shall be so entitled. So, in my respectful submission, the exercise of any of the powers under rules of the Supreme Court, Order 115, be they under the 1988 Act, the 1994 Act, or any of the other acts that I've referred to, is both substantively and nominally part of the criminal process. They are proceedings in respect of an indictable offence. Whilst the exercise of these supporting powers may be civil in the sense that civil procedural law applies, including civil routes of appeal, it is about as far away from ordinary civil litigation as mentioned. Aside from the fact that the primary benefit or the initial benefit of any order made inures to the Crown, something of public rather than private utility, the removal of assets from the criminal is of obvious public utility, as it deprives habitual criminals of the funds to commit further crimes. This may be particularly true of drug trafficking. In that regard, if I could ask you to turn to page 331 of the bundle, which I think is 14. This is I'm going to take to paragraph 14. This is an extract from the speech of Lord Stein in R versus Resvi, 2003, appeal cases 1019.
Sorry, I've got right. We're on Resvi, are we? Right.
Yes.
Sorry,
Yes. So page 331.
Page 331,
which I think is tab 14.
thank you. Thank you.
And I'm going to take you to paragraph 14, which reads as follows. It is a notorious fact that professional and habitual criminals frequently take steps to conceal their profits from crime. Effective but fair powers of confiscating the proceeds of crime are therefore essential. The provisions of the 1988 Act are aimed at depriving such offenders of the proceeds of their criminal conduct. Its purposes are to punish convicted offenders, to defer the commission of further offences and to reduce the profits available to fund further criminal enterprises. These objectives reflect not only national but also international policy. The United Kingdom has undertaken, by signing and ratifying treaties agreed with the auspices of the United Nations and the Council of Europe, to take measures necessary to ensure that the profits of those engaged in drug trafficking and other crimes are confiscated. See the following. A certain number of conventions are referred to. I didn't take you to them because they were very similar to the provisions I've already taken you to, but if I carried on going through Part 6 of the Act, you would have found that there were corresponding provisions relating to international confiscation orders, in other words, confiscation orders made by courts elsewhere. But the point I want the court to note from this paragraph is that the prosecutor is not there in a private capacity. The prosecutor is there for the purposes of prosecuting a crime in order to obtain confiscation that may ultimately partly end up in his or her pocket, but initially goes to the Crown, and most importantly, deprives the criminal of the funds for committing further crime. And there is a considerable public benefit to that. And again, I say that is part of the criminal justice process, in the sense that that the enforcement of a confiscation order is something which relates to an indictable offence. So for all of these reasons, the exercise of supporting powers in Part 6 of the 1988 Act, or any of the other acts previously referred to as being associated with RSC Order 115, is part and parcel of the criminal process and are proceedings in respect of an indictable offence. It is not in dispute that they are governed by civil procedural law, including civil routes of appeal, but that is not the question. In my learned friend's replacement skeleton argument, paragraph 15 and 16, my learned friend says that the power of a prosecutor derives from Section 6 of the 1985 Act, and he says that the power to appoint payment out of central funds also arises out of that Act, and that Act relates only to criminal proceedings. He refers in that regard to Steele, Ford and Newton. I'll come to that case a little later on, but additionally he cites the government of the United States versus America, Montgomery, 2001, one Weekly Law Reports, and also Oldham versus the Crown Prosecution Services, 2010 England and Wales Court of Appeal Civil Division 961, as being authority for that proposition, and that proposition being, I just remind the court, that the 1985 Act relates to criminal proceedings. In my respectful submission, no part of those submissions bears scrutiny. Firstly, the power of a private prosecutor does not derive from Section 6 of the 1985 Act. I'll just take you to that section. It's at tab 4. Sorry, I do apologise. It is at tab 2. And is at page 11 of the bundle. So in some way, my lowest friend says that in some way this provision restricts the applicability of the rest of this Act to criminal proceedings only. Well, in my respectful submission, it doesn't. All it does is it preserves the power of a private person to act as a criminal prosecutor. It certainly doesn't create any such power. And it is not surprising that this Act has expressly mentioned the fact that a private prosecutor may continue to act, because this, as I've already mentioned, was the Act that created the Crown Prosecution Service. So in those circumstances, it is only natural that Parliament would want to clarify what role people who were not the Crown Prosecution Service may have insofar as private prosecutions are concerned. And that is all that Section 6 does. It has no bearing at all on the operation of Section 17 of this Act, which of course is the section relating to central funds payable to prosecutors. Secondly, there is nothing in the 1985 Act that says that the Act as a whole, or Part 2 of the Act, or in particular Section 17, relates only to criminal proceedings. Those words simply do not appear anywhere. Instead, Section 17 is worded in the way that I mentioned, namely in respect of any proceedings in respect of an indictable offence. And as to the authorities of the government of the United States and Montgomery and Oldham are concerned, neither of them say anything at all about the scope or operation of the 1985 Act. Instead, they merely confirm what is not in dispute, namely the fact that enforcement proceedings in the High Court are civil proceedings in the sense that they are governed by civil procedural law, including civil routes of appeal. In particular, Montgomery concerned the issue of whether the criminal nature of proceedings precluded a civil right of appeal. And Oldham was about whether or not the CPR or the criminal practice rules applied for the purposes of considering the incidence of costs between opposing parties. And those have no bearing at all on the operation of Section 17 of the 1985 Act. There is no reason why proceedings cannot be governed by civil procedural law and yet still be proceedings in respect of an indictable offence. The rules that govern procedure are born of entirely different considerations to the rules that govern funding. Indeed, in this regard, it is worth noting that the criminal procedure rules may occasionally adopt the civil procedure rules from time to time. I'll give you just one example. Criminal Procedure Rule 3343 occasionally allows the Crown Court to adopt certain procedures in relation to disclosure. But it would make no sense at all to say that if the Crown Court were to do that, that part of the proceedings would cease to be in respect of an indictable offence. Put another way,
what do you say, forgive me for interrupting, what do you say about what Lord Hoffman says of paragraph 19 of Montgomery? He says in the opening part, sentence of paragraph 19, perhaps lend some support to what you're submitting.
My Lord, forgive me, I'm struggling technologically at the moment. I'll catch it.
Page 253 in the bundle.
Thank you.
Authorities, 253.
I have that now, thank you. Yes. Yes, well, paragraph 19 the following said, my lords, it may be right, possibly in most cases would be right, to regard orders made by way of enforcement of orders made or to be made in criminal proceedings as part and parcel of those proceedings. This was certainly the case in R versus Steele, 2 Division 37, but I would not accept what I regard as the extreme proposition of Mr. Alan Jones, that the nature of the proceedings in which the original order made will necessarily determine whether the machinery or enforcement through the courts is a criminal cause or matter. Modern legislation, of which Part 6 of the 1988 Act is a good example, confers powers on the criminal courts to make orders which may affect rights of property, create civil debts, or disqualify them from pursuing occupations or holding office. Such orders may affect the property and obligations not only of the person against whom they are made out of a bit of third party as well. Thus, the consequence of an order in criminal proceedings may be the claim or dispute, which is essentially civil in character. There's no reason why the nature of the order which gave rise to the claim or dispute should necessarily determine the nature of the proceedings in which the claim is enforced or the dispute is determined. Yes, in many ways, I'm relying on that for the purposes of being in this court, because if the proceedings were a criminal cause or matter, then this court would be precluded from hearing this appeal by virtue of Section 18 of the Senior Courts Act, Senior Courts Act 1981. But the question as to whether or not a matter is a criminal cause or matter is not the same as whether or not whether or not proceedings are in respect of an indictable offence.
I'm speaking for myself, I would agree with that, but I was wondering whether you might not be placing positive reliance for the purposes of your argument on the first sentence of paragraph 19.
Indeed, absolutely. I do, and also on R versus Steele. I won't take to that case because it essentially just illustrates the same point. So I do very much place reliance on the first part. The reason why one has to distinguish between how the court deals with the question of whether or not the issue is a criminal cause or matter, and whether whether the proceedings are in respect of an indictable offence is that entirely different policy considerations apply. When considering whether or not it is a criminal cause or matter, one essentially is deciding an issue that will deal with the route of appeal and with distribution of appeal cases amongst the senior judiciary. And to that extent, a relatively pragmatic and policy-based approach seems to have been taken, in the sense that the most recent of those cases referred to by Lord Justice Davis in his email of yesterday, in Montgomery, has explained that there ought to be a slight narrowing of.
You mean McGuinness?
McGuinness, yes, it has escaped my mind. Yes, yes. I'll say it of course in a second, but it has formed a view as to the meaning of criminal cause or matter, which is based on to a certain extent on policy. The considerations applied to Section 17 are entirely different. So I'll come to that in a moment.
Now, Mr. Thiston, sometimes we break when we have these remote hearings for 10 minutes or so in the morning, in the afternoon, Can I ask, are you on schedule to complete your submissions by 1 o'clock?
I may just tip over. I would hope so, but it's possible that I may just slightly tip over.
Well, in that case, I think we'll carry on.
Well, just a moment. I just want to review how much I left. Yes, I probably will just tip over, I'm afraid. Right. In fact, may I please take the court to McGuinness? And you'll find that in the second authorities bundle, beginning at page 67. I think it's probably tab 4.
Dr. President, speaking for myself, I'm not trying to flog the jurisdiction point on which you're all agreed.
Oh, I see.
This case, in case it casts light on the interpretation of the 1985 Act.
Oh, that's very helpful. Well, the point I was going to make was that there's very little that can be gleaned from any of these cases, because the way in which the court approached the question of criminal cause or matter is entirely different to the way in which I say that the court should approach the question of interpretation of Section 7.
As you point out, the language and policy of the two sections are quite different.
Indeed.
So,
Well,
anyway, speaking only for myself, I'm not particularly now interested in view of your agreement in McGuinness, unless it bears on the interpretation of the section.
well, it doesn't. That was the point I was going to make, that there is a distinction. And if
That, of course, is subject to my lord and my lady.
so unless the court invites me to do otherwise, I'll move on from that point.
Thank you.
My learned friend places great reliance on Steele, Ford and Newton, and it is to that case that I now ask the court to turn. And you will find that in the main authorities bundle at tab 11. Now, if I may just begin by explaining the facts. There were 4 firms of solicitors, and each had been ordered to pay wasted costs by the Crown Court acting of its own initiative. They appealed to the Civil Division of the Court of Appeal under Section 50 of the Solicitors Act, and thus the Crown Prosecution Service took no active role in the matter. And each of those solicitors succeeded on their appeals, thereby escaping the order for wasted costs. Now, it's worth pausing here to note that these cases were wholly civil cases. This is because at the time, Section 50, I don't need to take you to it, but Section 50 of the Solicitors Act expressly provided that anyone to appeal was to the Civil Division of the Court of Appeal. As such, they have no connection at all with the criminal proceedings, save for the fact that the allegedly negligent, improper or unreasonable events took place in the context of Crown Court proceedings. As I say, the solicitors sought their costs at the end of the appeal, and the Court of Appeal allowed those costs, and the matter was then appealed to the House of Lords. And it is important to note that that the solicitors made no attempt to bring any of their arguments within the ambit of the provisions, or there was no attempt to rely on any of the provisions of Part 2 of the 1985 Act that makes express provision for payment of costs under central funds. Instead, what they sought to do was to rely on a wider power conferred by Section 51 of the Senior Courts Act to seek an order of costs central funds. Put another way, the solicitor did not seek an award out of central funds pursuant to the code that governs payments out of central fund, of which Section 17 of the 1980 Act is a part. Instead, they simply sought an order for costs, this being effectively in an attempt to sidestep, to avoid the provisions that govern the making of actual awards to prosecutors and defendants. This was in the early 1990s, and this was a time when the jurisdiction to make non-party costs orders had yet to move from nascency into maturity. The House of Lords had recently identified the far-ranging reach of Section 51 of what was then the Supreme Court Act 1981, that being in the case called Aden Shipping Company versus Interval Included, 1986, appeal cases 967, but no senior court had yet examined that jurisdiction in any detail. And the central question that the Lordships have to answer may be found at page 229 of the authorities bundle. This being on page 24 of the report. At E, the provisions of Section 51(1) of the Supreme Court Act should not be considered as conferring a discretion to award costs out of central funds in all proceedings in the High Court and in the Civil Division of the Court of Appeal. So that was the Lord Chancellor's case, and essentially the question the Court had to answer. The Lord Chancellor went on to point out that central funds had no legal persona, and payment out of central funds was tightly controlled by specific legislation, and that with one or two exceptions, such as licensing matters, that it was always limited to criminal cases, causes, or matters. The Lord Chancellor pointed out that orders for payment out of public funds are unlawful unless authorised by statute. Both the solicitors and the CPS countered this. So the Crown Prosecution Service supported the solicitor's case that they should be awarded costs out of central fund as a costs order. The solicitor said that the power of the civil court to award costs is a wide and general one. They accepted that the court's discretion as to costs in the criminal courts was subject to what they called a precise code, but they contrasted this with the practice in civil courts where no such code exists. And they argue that there is no reason why the power to determine by whom costs should be paid should not include a power to determine those costs should be paid by Parliament. And if I can ask you to turn to page 231. At E, you can see that the solicitor said the power of the Civil Division of the Court of Appeal to award costs is a wide and general one. It contrasts with the powers of the Criminal Division, which are narrow and specific. And then at H, you can see that the solicitors noted that the word central funds are bound to appear where the question of costs is the subject of the statutory code, but those words are not bound to appear where there is merely a general power. And then on the next page, at A, you can see they argue that there is a presumption that Parliament does not intend its legislation to produce highly inequitable results. And of course, the reason they were saying that is because the original wasted costs order was made at the court's own, on the court's own initiative, and therefore it would be inappropriate to have ordered costs against the prosecutor. In that instance, was the Crown Prosecution Service. And then at C, you can see that they draw a distinction between costs and an award simpliciter, and what they were asking for was costs. And they argued there was no reason why costs should not come from central funds. And then if you turn to page 233, halfway down the page at E, you'll see that the Crown Prosecution Service essentially supported the solicitor's case, and at E, they said that orders for payment out of central funds are illegal unless authorised by statute. They said that orders for payment out of central funds are illegal unless authorised by statute. It does not prevent the court from making an order under Section 51 for a payment of costs out of central funds. They had the solicitors had one or two other arguments, but I don't think I particularly need to trouble the court with those. In essence, they said that Section 50 of the Solicitors Act 1974, which governed the jurisdiction of the senior court service solicitors, necessarily implied there was a power to order that costs were paid out of central fund, and they said funds the same much same thing about Section 19A of the 1985 Act. But I don't think I need to trouble the court with those points. It's the main argument that was relevant. And I pause here to say that if the solicitors and the Crown Prosecution Service had been correct, the court would have had jurisdiction to award costs out of central funds in any civil case. And this would have been, for all purposes, all practical purposes, unregulated public funding by the back door. So it is no surprise that their lordships express some concern about this. If I could ask you to turn to page 234.
So I don't want to cut you, Mr. Friston, I don't want to cut you short, but can we not get to the point? You're distinguishing this case. This case is about Section 51 and the powers in relation to it. I mean, I assume at the end of the day your point is it's a completely different provision relating to a completely different matter and has no bearing on Section 17. I mean, you're spending a long time going through this case, but are you going to be saying anything more than that at the end of the day?
I'm not, the only other point I was going to make was that there was mention of Section 17 and Section 16, but it was extremely brief.
Dr. Friston, it isn't really the bull point, the one you find at page 29E, page 234 in the bundle.
Yes. Indeed, that's exactly right.
So no express statutory authority to make such order could be invoked. And your argument is that here there is express statutory authority.
Indeed.
And that's your point, isn't it? And that then brings us back to the question of interpretation. Whether Section 17 does confer express statutory authority. Isn't that the bull point?
Indeed it is, yes. It's clear that the court has already looked at Steele, Ford and Newton, and I think the court already has the points that I was going to make in respect of that.
And it was the case which appeared to persuade Mrs. Justice Jefford
Indeed.
To reach the conclusion she eventually did.
Indeed, yes. My lords, could you just give me 1 moment? I just want to, there's quite a lot of points I was going to make that I no longer need to make. I just want to reorientate myself in terms of my notes. Yes. The only other point I was going to make in going through Steele was I was going to accept that it must follow from what the lordships have said that the court will interpret any rules that give a right to, or a putative right to, award out of central funds in relatively narrow terms, and to use the Lord British phrase, in clear and express terms, and that those are required before an award out of central funds can be made.
Also, so is that the issue at the end of the day, using the language you've just used, which is is Section 17 clear and express language that allows the payment out of central funds. Is that the ultimate question of interpretation? Are those words clear and express?
I'm not entirely sure that the words clear and express are the test, but certainly there needs to be an express provision.
I'm sorry, I thought you just said that I'm so sorry. I may have misinterpreted what you said. I thought you were saying that the only other point you wanted to make on this case was that that their lordships thought that there should be clear and express terms for payment out of central funds.
Yes. That is right. What I'm not sure is whether or not that is the actual test that one applies, but certainly that is.
Well, do you want us to? I mean, that's quite an important point. I mean, at the end of the day, that's exactly what we're trying to do. We're trying to interpret Section 17(1)(a),
Yes.
and we're trying to understand whether the wording there is sufficiently. Well, we have to find out what the test is. Is the test sufficiently clear and express? Is it unambiguous? If there's something in this case here which helps us on what the test is, then that is something I'd like to see.
I'm not sure there is, but I do accept that in order to be power out of to award a payment out of central funds, that there must be an express provision, and I do accept that provision must be tolerably clear. But even if one were to...
Now, what does that mean? I'm so sorry to pick you up on these points, because they're rather... When you say it must be tolerably clear, what does the word tolerably mean there?
What I mean by that is that if there is ambiguity and that ambiguity is capable of being resolved, then that is what the court should do.
And Dr. Friston, the other point is that in relation to this case, that the court, the House of Lords, was considering an argument that there was an implied that there was an implicit power to order costs, and it was against that background that the words were used by Lord Bridge, for example, on page 238 at C2G, because he was dealing with the argument that the alternative argument that which one sees at page 237 or 32 of the authority, the alternative submission in support of the orders made by the Court of Appeal, that's at H, was that a power to order payment of costs out of central funds was to be implied.
Yes, indeed.
And it's against that background that the rather strong words are used over the page, or at least so it seems to me. One goes over the page and where there's a reference to clear, express and unambiguous language, for example.
Indeed. So certainly there needs to be a clear and express power for there to be an award in principle. But in order to work out the extent of the court's power to make an award, it may be the court has to interpret. But that may be a moot point or an irrelevant point in any event, because in my respectful submission, Section 17(1)(a) is clear, and it is express. It says that the court may make an award in any proceedings.
So do you accept, I'm so sorry, I'm finding it difficult to pin you down.
Yes.
Do you accept that the test is clear, express and unambiguous language? Do you accept that that's the test, or do you not?
Those in the context of deciding whether or not a power exists then yes, that is the test. In the
you might want to think about this a bit. As my lady has said, Steele Ford was all about whether or not you could imply such an power, and what the House law said is you can't.
Yes.
What you have to find is an express power in the statute. That is a matter of interpretation. Speaking for myself, then to go on and add epithets like clear and unambiguous is simply a gloss. It's a binary question, as nowadays we put. Yes or no, does the language of the statute make explicit that that is a power to order costs out of central funds? I think you might want to think about whether or not it's simply a gloss to say you also have to add in words like unambiguous and clear. It's either yes or no. Is it explicit?
If the question is there a power at all, then it has to be expressed. So in other words, if the question is, can we just conjure up out of thin air a power to award costs out of central funds, then the test is as set out by the lordship. But insofar as looking at a provision which clearly relates to central funds and looking at the extent of that provision, so in other words, insofar as the process of interpretation is concerned, then in my respectful submission, the test as suggested by Lord Bridge does not apply. That would only really apply when we're talking about trying to imply, almost conjure up out of thin air, a power to make an award. Here, we're talking about the interpretation of Section 17, not whether or not some power is implied by virtue of just ordinary fairness or whatever it may be into some completely unrelated section. And that's what, in essence, what the solicitors attempted to do in Steele Ford. But in any event, I say, so in essence, I don't accept them as a gloss, and the court just simply has to look at the words and to determine what they mean. But in any event, there is a clear and express power, and that power is in any proceedings in respect of an indictable offence. It does not say in any criminal proceedings. It does not say in any criminal cause or matter. It does not say in any proceedings in respect of an indictable offence, save for proceedings in the High Court. It is a simple, unvarnished, easy to understand phrase, in any proceedings in respect of an indictable offence. And in my respect,
at the time the 1985 Act was enacted, of course the Criminal Justice Act and the Drug Trafficking Offences Act didn't exist.
Yes, indeed.
So presumably this section was drafted without any regard to the prospect of confiscation proceedings.
To be fair,
was there a confiscation process available by any other route at the time of the POA?
no, I've looked into this. The first provisions came into existence in I think January of the next year. So
what I thought. So it may be a neutral point, but what one can now deduce is that the 1985 Act simply would not have had in mind the availability or possibility of confiscation proceedings in the High Court.
Indeed, I think that must be right. To be fair, I think I need to draw attention to the fact that I believe that the bill that I mentioned would become the 1986 Act was working its way through Parliament, but the actual legislation had not yet been made. And so I submit that the ambit of Section 71A would certainly include civil proceedings where Parliament has said that in respect of an indictable offence, a prosecutor, if required or permitted, to take certain steps in the civil courts which are consequent upon part of the criminal justice process. Indeed, the ambit of that section may even go further. It may be such that a prosecutor, for example, sends an inquest for the purpose of taking a note of evidence, that may also be included, but that's for another day. In my respectful submission, where an act, such as the 1988 Act, makes the prosecutor into a central actor for the purposes of a central part of the criminal process proceeding, the part that actually gives effect to the confiscation order, that must fall within the meaning of any proceedings in respect of an indictable offence. And I note that paragraph 19c of the skeleton argument, the Lord Chancellor has said that the prosecutor has created a quandary for himself by having failed to explain how the power to take an award of central funds in enforcement proceedings dovetails with the power to award costs under CPR 44. Well, that's neither here nor there. The answer to that is that an award of central funds and costs between opposing parties are not the same. They are as distinguishable. They are as distinguishable as costs in legal aid, or for that matter, costs in damages-based payments, or costs in any other type of funding that may be overseen by the court. One relates to costs between opposing parties, the other relates to funding. The only way in which they need to dovetail is the prosecutor would not be entitled to double recovery. Paragraph 19 E of the skeleton arguments, the Lord Chancellor tries to persuade the courts that these things do not relate to an indictable offence, and he says that this is because the criminal takes no part, and they are proceeding solely between the prosecutor and the third party. Well, the short answer to that point is that this is not what Mrs. Justice Jefford found. There is no respondent's notice to that effect. But in any event, the argument is simply wrong. This is because the application notice or claim form must be served on the defendant. And I've already taken the courts to the relevant provisions in that regard, that being Rule 7.2a of Order 115. Any application or Part A claim must be entitled in the name of the defendant, naming him in the matter of the Act. All subsequent documents in the matter shall be so entitled. The defendant has the rights to be heard and may well have an interest. Under Section 83 of the Act, the defendant has a right to make an application that may lead to a certificate of inadequacy being issued. And I could go on and on. There are many reasons why it's right to say this was simply an extension of the criminal justice process, albeit one covered by civil procedural law, and that both the prosecutor and the defendant were involved, even though the defendant in this particular case may have chosen not to take a particularly active role. Finally, the Lord Chancellor says that paragraph 20 of his replacement skeleton argument that the indictable offence has no relevance to the nature of the enforcement proceedings other than providing a basis for the confiscation order. What I expect to suggest this is looking at the matter from one end of the telescope. The question is not whether the indictable offence relates to the enforcement proceeding, but whether the enforcement proceedings relate to the indictable offence. They clearly do, because they are the means of enforcing the sentence of the court. Moreover, they are not only consequential to sentencing, but are integral, because if a certificate of inadequacy is issued, the Crown Court may well vary the confiscation order and impose a reduced term of imprisonment or detention under Section 139 of the Powers of the Criminal Court Sentencing Act 2000. So for all these reasons, the views expressed by Mrs. Jefford at paragraph 47(1) of her judgment, that's it at page 53 of the court bundle, those views were, with respect, entirely correct, but with equal respect, I say the views expressed at paragraph 47(2) were wrong. Having made those points, I will 53 of Mr. Justice Jefford's judgment. I was going to take you to that's at page 53 of the court bundle. This is where Mr. Justice Jefford said there is further support for that in the fact that it is surprising if the prosecutor could recover out of central funds unless Section 17 in circumstances where the defendant could not under Section 17 in circumstances where the defendant could not under Section 16. So in other words, Mr. Justice Jefford has taken as being an aid to her interpretation of Section 17 a comparison with Section 16 as being an appropriate aid. I respectfully submit that the comparison of the two sections is not an appropriate aid to interpretation. It is wrong to assume that Parliament would legislate for any form of equivalence between prosecutors and defendants. Sections, I'll take you to section 16. It is at tab 2, at page 12. And it's also just worth pointing out that there is now a section 16A, which we'll find at page 15. That section having been inserted by LASPO. And one only has to glance at either of these two sections, section 16 in particular, to realise that it is drafted in considerably more restrictive terms than Section 17. And this is for obvious reasons. It is generally in the public interest for prosecutors to act in that capacity, subject, of course, to the oversight of the court. But it's entirely different considerations may apply to defendants. Insofar as enforcement proceedings are concerned, in particular, the defendant will have been convicted of a crime, and I respectfully submit that that fact of itself means that different policy considerations would apply when comparing a prosecutor to a defendant. The prosecutor will simply be acting.
Can you help me on this point? Where the claim is against a third party on the basis that it's a tainted gift,
yes,
is the third party named as a defendant?
I think the third party is named as a party, but they are treated as being a defendant, and certainly they may be entitled to pass as between opposing parties.
Well, yes, but so I'm only trying to understand how this fits in, because you said that the defendant would have been convicted, but if it's a case of a third party who is resisting a claim for enforcement of the imposition of an order against their property or its sale or realisation, well, plainly they're not somebody who's been convicted, and if they succeed, why should they be treated any differently from the prosecutor?
Oh, I see. I think that you're drawing a distinction between two types of defendant. There are the defendants in the original criminal prosecution, and they, of course, will have been convicted. And then there are defendants in the confiscation proceedings who are third parties, as it were. They are people who are said to be in possession of a tainted gift. I don't think it's being suggested that a defendant's cost order could be made in respect of those people. There would be no need, because if they're successful, they'll be awarded costs will follow the event.
Yes, but hang on. How do we know that the appellant would be... I mean, one of the advantages of getting your money out of the central funds you don't have to worry about whether any other party can afford to pay them. I mean, they may not have any money, and so that would be very convenient. But who knows whether the prosecutor, in any particular case of a private prosecutor, who's brought proceedings, as in this case, which seeks to recover or realise tainted goods, has the money. So that they would be in a very, very different position. In that case, if you're right, the third party would be dependent, first of all, of course, on recovering, making an order for costs, I think you would say under Part 44, and they would be at risk of not being able to recover the costs.
Indeed, if those were the facts, then yes, I'll call them the third parties to distinguish them from defendants in the original prosecution. If those were the facts, then yes, a third party may indeed be to disadvantage.
Anyway, you say the section.
Sorry, I'm not quite clear what your submission was. Then, can you repeat it, please?
I was responding to the question about what would happen if the prosecutor were not good for the money, and wouldn't that create an imbalance between the prosecutor and what I'm calling a third party, by which I mean a defendant in the gift issue. So not a defendant who's been convicted, but a defendant in the gift issue. And I have to accept in those circumstances that yes, there would be an imbalance. But whether that is whether those, one would hope, very unusual facts is something that is an aid to interpretation of Section 17 is another point. Somebody who is pursued as a third party in a gift issue may find themselves in no different position to any other defendant in a civil claim, in the sense that they ultimately may end up having to bear their own costs.
Can I just ask Dr. Friston, in this case, just to bring it back to the facts, on the the claim for payment out of central costs, central fund, fund covered the costs order that was made by Mrs. Justice Jefford. Assume for a moment that the prosecutor loses.
Yes.
Are you saying he's only entitled to get his costs, or could an order be made against him and central funds would end up having to bear the costs of both sides if the proceedings were unsuccessful?
My lord, may I just check you can still hear me, because my computer is flashing up saying that there's a problem with the internet. Are you still able to hear me?
Yes, yeah. I can hear you.
Okay, well, thank you. In my, if the prosecutor were to fail, as in the facts of this case, and were to have costs awarded against him, then the prosecutor would be liable for the costs. And yes, my case is that in those circumstances, the prosecutor is able to recover both sets of costs from central funds. So,
which would mean there wouldn't be any inequality on that basis, because the prosecutor would be liable to pay the costs of the person whose gift wasn't untainted, the third party.
Well, the likelihood of inequality would be significantly reduced.
Yes.
I suppose that theoretically, the prosecutor could become insolvent or something. But on my case, there is a mechanism there for in ensuring that both parties are on a relatively equal footing.
That assumes you're succeeding in your second point.
Indeed it does.
In other words, you're going to recover. Although you've lost, you're going to recover all your costs from central funds.
Well, yes, of course, we're talking here about funding
and expenses, and that these are expenses. I mean, that only works. Anyway, look, it doesn't really matter. This all arose because you were making a point about Section 16, and I wanted to know, because I simply don't know, whether a third party is also, for the purpose of these, what you describe as procedurally civil proceedings, whether the third party is also a defendant to that claim for realisation of their assets. I have no idea. But you tell me that they're never described as a defendant, and they're always described in some other way. But I have no idea. Is that right?
Well, no, I have to put my hands up and say, I am a cost practitioner, not a criminal practitioner.
Well,
so I'm not sure of that.
I have to say that I don't think there's too much precision of practice in the Crown Court, but very often the third party will be an applicant.
No, I appreciate that.
Say the wife will turn up and say, well, you've made an order against the whole house, but actually I have half the beneficial share, interest in it. And she, in point of practice, will be the applicant, arguing that she has half the beneficial interest in the house.
Yes, but that wasn't the position here.
It wasn't the position here, but that often does happen in the Crown Court.
I understand.
And of course, there is provision for that.
Anyway, I think we've exchanged views about this enough, so there's no point in spending any more time on it.
Yes. Well, but the point I want to make about Section 16 is it is drafted in entirely different terms, and different policy considerations apply. Finally, on the point of equivalency, paragraph 34 of my Lord Frost's argument, he says that there is authority for, and I quote, describing sections 16 and 17 as equivalent provisions. This is wrong. The two authorities that is referred to simply refer to the fact that those sections contain equivalent provisions, and this is obviously not the same thing. So, for example, my friends have referred to our law society versus the Lord Chancellor 2010, England vs High Court 1406. The only comments that were made in that case related to the way in which awards of costs are quantified, and of course there's equivalence there. It's exactly the same method. And likewise, in R versus Mirchandani versus Zinger 2014, England Wales Court of Appeal Criminal Division 1823. Again, that's related simply to the measure of costs as opposed to any other type of equivalence. Paragraphs 21 to 23 of his replacement suspension argument, my learned friend makes the point that monies that may be recovered by way of enforcement proceedings may not be the same monies that were the fruits of the crime for which the defendant was sentenced. And he concludes by pointing to the putative absurdity, for example, of a prosecutor pursuing inherited monies that were bona fide given to a charity. There is nothing in these points that is relevant to the interpretation of Section 17 of the 1985 Act. Instead, they are issues that go to the exercise of discretion to make an award out of central funds. And in this regard, it should be borne in mind that Section 17 says that the court may, not must, make an award. And if a private prosecutor has pursued a brass-necked and obviously hopeless case in respect of a gift that was not tainted, then no doubt the court would decline to make an award. Paragraphs 24 to 26 of the present statute document, the Lord Chancellor correctly makes the point that the receiver has the power to realise tainted gifts, and goes on to say that it would be curious if the public purse were to bear the costs of pursuing putatively tainted gifts in circumstances in which the receiver has supposedly chosen not to do so. Again, this point is irrelevant for the purposes of interpretation, as it points that goes to the exercise of discretion. There's no evidence as to what the receiver in this case did or did not do. but if the prosecutor acted unreasonably in this regard, then no doubt the court would exercise its discretion accordingly. Paragraph 27 of his replacement schedule, Margaret Friend, makes the point that under the 2002 Act, the costs of enforcement proceedings are governed by the Criminal Procedure Rule, Part 33, and that under those rules, costs follow the event. The Lord Chancellor goes on to say that if this appeal is allowed, then there will be a division of liability of the public purse for enforcement actions taken before the changes invoked by the Police and Criminal Evidence Act. This is not so, indeed quite the opposite is true. If this appeal is allowed, then the court will have the power to make an award of central funds in all enforcement proceedings, whether they're in the High Court or the Crown Court, and as between parties, the court will have the power to make awards of costs. If this appeal is not allowed, on the other hand, then whilst costs will follow the event in both courts, the court will lack the power to make an award out of central funds in the High Court. This being in contrast to the fact that it is likely to have such a power in the Crown Court. So if my learned friend is seeking equivalency between the old regime and the new regime, then that equivalency will be achieved by allowing this appeal, not by refusing it. So that, I think, deals with some of the points arising out of paragraph 47(3) of Mrs. Justice Jefford's judgment. I now move on to the points that she considered at subparagraphs 4 and 5, this being secondary legislation and practice directions. And this is the point that she regarded as being particularly persuasive. The question here is whether Mrs. Justice Jefford was right to use delegated legislation and practice directions, or either to find that Section 17 of the 1985 Act was not in place in enforcement proceedings under the 1988 Act. I begin by saying that there is no dispute that secondary legislation made under an Act that is made at broadly the same time as that Act may be taken into account as being an extrinsic aid to interpretation. Similarly, it seems to be agreed that practice directions may be taken into account, but only as a weak aid to interpretation. The question is not whether such aids to interpretation may be taken into account, but whether Mrs. Justice Jefford ought to have taken it into account in the way that she did, for the purposes of reaching the conclusion that she reached. If I could just take you to the judgment, please, which you'll find in the core bundle at page 47. I'm going to go through this very, very quickly. You can see that at paragraph 27, Mrs. Justice Jefford began by noting that if the court does not fix the amount of costs payable out of central funds pursuant to section 17(2)(c) of the 1988 Act, the amount, sorry, 1985 Act, the amount must be fixed in accordance with the procedures specified in regulations made by the Lord Chancellor. And she went on then to note that the relevant regulations of the Costs of Criminal Cases General Regulation 1986, made under sections 19 and 20 of the 1985 Act, paragraph 25. Then at paragraph 29, she went on to note that these regulations provide, at regulation 5, that an award will be determined by the appropriate authority. And then she concluded that whilst there is an appropriate authority for the division court, there is no appropriate authority for a single judge sitting in the administrative court. And she regarded that as being a significant factor that pointed away from section 17 covering these proceedings. It is respectively, so in other words, she identified what she believed to be a hiatus in the mechanism for determining the amount of costs or the amount of the award made out of central funds. And it is true to say that there's nothing in the 1986 regulations, or indeed in the practice direction, that expressly deals with the position where a single judge of the High Court has made an award of costs, made an award out of central funds. It refers only to the division of the court. So there is a hiatus. But it is respectfully submitted that this seeming hiatus in the 1986 regulations is at best only a very weak aid to interpretation to the 1985 Act. This is for the following reasons. Firstly, the interpretation of the 1985 Act contended for by the Lord Chancellor would mean that a prosecutor may secure a conviction and a confiscation order, and then, notwithstanding the fact that Part 8 of the 1988 Act encourages them to be an essential actor in enforcement proceedings, fall off a cliff insofar as funding was concerned. If that genuinely was the intention of Parliament, one would have expected it to be expressed by means significantly more explicit and clear than a mere hiatus in delegated legislation that related to the determination of awards of essential funds. Put simply, it's too obscure. Secondly, to the extent that there is a hiatus, it is easily found. In the Respondent's skeleton argument on the 13th of December 2018, the following submissions were made at paragraph 21D. It's probably no need for you to turn to it. I'll read it out. It's page 47, it's supplementary bundle there. My little friend said this: there is no appropriate authority in respect of the High Court other than in the case of proceedings in a divisional court of the Queen's Bench Division, in which case it is a master of the Crown Office. This is mirrored by the Administrative Court Judicial Review Guide 2018, which provides that there is no power for a single judge to order costs to be paid out of central funds. So my learned friend there has correctly quoted from the Administrative Court Judicial Review Guide. If I may ask you please to turn to that, and you'll find that in the authorities bundle at page 476. That being tab 24, I think. So the sorry, Dr. Kristen, whereabouts are you? I'm in the appeal. In the authorities bundle at 476.
Tab 24.
I think it's tab 24. Yes, it's the Administrative Court Judicial Review Guide.
So where does Mrs. Justice Jefford deal with this?
She doesn't.
Well, why are we looking at this now? I mean, this is a point surely to be raised by the respondent. And you'll have an opportunity to answer it. I thought you were dealing with points we hadn't covered, which are Mrs. Justice Jefford's judgment.
Yes. The reason I'm dealing with this now is because it explains why Mrs. Justice Jefford...
Well, I really don't mind, Mr. Friston, but I'm going to tell you that you're going to run out of time if you go over the lunch adjournment. I'm going to give you a quarter of an hour. That's all you'll have, because we have to have a fair opportunity for both sides. So you must distribute your submissions as you wish, but you must bear in mind you will not be able to go on after 2:15.
Right. Well, this is an important point, and the reason it's an important point is because Mrs. Justice Jefford was persuaded by the fact that there was a hiatus insofar as the provisions for determining the amount of costs are concerned. And she thought that was a relevant factor that pushed her towards making the decision that she made. And the point that I'm making is that the answer is actually in the very guide to which my learned friend referred the court, and that is at paragraph 2311.4, which you'll find on page 476, where the following is said: there is no power for a single judge to order costs to be paid out of central funds. Where a claimant seeks an order for costs from central funds, when appearing before a single judge, the judge will adjourn the matter and be considered on the papers by a divisional court constituted by a single judge who heard the case and another judge. So if there is a hiatus, it was easily gapped. And it was easily gapped by simply by the court saying, well, I would like to make an award of central funds, but because of this hiatus, I'm unable to do so because there's no appropriate authority, and in those circumstances, I will reconstitute and sit with another judge as a divisional court.
Sorry, I'm not following this. Why does referring it to a divisional court make all the difference? Because divisional court is only mentioned in the statute in the context of a summary offence.
So it's relevant because any high court considers divisional court is simply a court that is made up of more than one high court, more than one judge. And the point I'm making is, if Mrs. Justice Jefford was concerned about this hiatus, there is a mechanism for filling it.
Well, I don't quite understand where the administrative court judicial review guide gets it from.
Well,
perhaps the president of the Queen's Bench Division can help us.
Right. So, for all those reasons, I say that Mrs. Justice Jefford was wrong to interpret the Section 17 in the way that she did. I just want to deal with one final point in paragraph 42 of my learned friend's sketched on, but it says that enforcement proceedings are not proceedings in respect of an indictable offence. And he says that this is because Section 75(1) of the 1988 Act says that a confiscation order takes effect as if it were a fine imposed by the Crown Court. And he goes on to say that in Taylor versus Westminster 2009, England Wales High Court 1498, Mr. Justice Chancellor had noted that enforcement of a fine is far removed from big proceedings. The case in the case of an indictable offence. Well, the short answer to this argument is that there's no respondent's notice of effect. But in any event, it's a bad point. The regulations that Mr. Justice Chancellor was referring to related to public funding, not central funds, and they did not refer to proceedings in respect of an indictable offence, but proceedings in the case of an indictable offence. Again, the wording is entirely different. And in any event, I suspect the type of enforcement that Mr. Justice Chancellor was dealing with was that which relates to warrants and payments and provision orders and the like, not to enforcement within the meaning of Part 4 of the 1998 Act. I just want to say just a word or two about the way in which Mrs. Justice Jefford reached her conclusion in relation to that hiatus. And I just want to just briefly refer the court to her judgment in that regard. If I could ask the court to turn to page 47. As I've already mentioned, paragraphs 27 to 29 of the judgment, Mrs. Justice Jefford noted that the 1986 regulations made no mention of there being an appropriate authority in respect of a single judge of the High Court. At paragraphs 32 to 35, she referred to the 2015 practice direction and to the fact that it made no mention of an award being made by a single judge of the High Court. Then, at paragraphs 36 to 37, she referred to the fact that the criminal procedure rules, Criminal Procedure Rule 45.4, referred to the power of the court to make an award in criminal courts, but made no mention of the High Court. Then, at paragraph 38, she said, and I quote, that in these subsequent regulations and practice directions and the criminal procedure rules, it does not appear to be contemplated anywhere that proceedings in the High Court, other than the divisional court, could result in an order for payment of costs out of central funds. And then at paragraph 39, she found that these things are indicative, at the very least, of the common intention of the legislation in which section 17 does not apply to civil proceedings, even if they arise out of the commission of an indictable offence. The difficulty with this analysis is that neither the criminal procedure rules nor the 2015 direction apply in civil proceedings. As such, it is not surprising that they are entirely silent on the point. In any event, they will be extremely weak aids to interpretation at best. This being because neither of them were made contemporaneously with the 1985 Act, nor were they made pursuant to powers created by that Act. And it is respectfully submitted that Mrs. Justice Jefford then compounded this error at paragraph 40 of the judgment by pointing to the fact that CPR contained no provisions that allow for the assessment of costs awarded out of central funds. This was wrong, because awards out of central funds are never assessed. They are fixed by the presiding court pursuant to section 17.2b, or they are determined pursuant to 17, or they are determined by an appropriate authority. Fixing and determining costs are not the same as assessing. So for all these reasons, it is respectfully submitted that Mrs. Justice Jefford's analysis was misconceived and that she was wrong to give weight to the 1986 regulations and the 2015 practice direction. So for all those reasons, I invite the court to allow the appeal on ground 1. I now move briefly on to ground 2.
Before you turn to ground 2, is there anything you want to say about what Lord Justice Dyson said in the case of Lloyd?
Yes, I think this is in my skeleton argument. Yes, you will find this at paragraph 1.21 of my replacement skeleton argument, and also at 349 of the authorities folder. At paragraph 18, when Lord Justice Dyson said this, in our judgment, Mr. Saunt is right to concede that Article 6.1 applies not only to the confiscation proceedings up to the making of a confiscation order, but also to any subsequent proceedings to enforce the order by issue of warrant and commitment to prison. Actually accepts that proceedings are part and parcel of the confiscation proceedings, which in turn are part and parcel of the original criminal proceedings. They are no more separate from the original criminal proceedings than is the application for a confiscation order itself. They are not fresh proceedings involving determination of criminal charge within the meaning of Article 6, any more than the proceedings by which the prosecutor seeks confiscation order Article 6.1 applies, because as so rightly accepts, the enforcement proceedings are not part of the criminal proceedings. Were the position to be otherwise, we do not see how Article 6.1 could apply to enforcement proceedings at all. So that just underscores the fact that any of the supporting powers, as I referred to them under the 1988 Act, and indeed those under the other acts that I referred to at the beginning of my submissions, can be regarded as being part and parcel of the proceedings in relation to the indictable offence.
Well, I'm sorry, is that right, Mr. Friston? Because paragraph 18 is worded extremely carefully. What Lord Justice Dyson is linking to the making of the confiscation order is the specific issue of subsequent proceedings to enforce the order by the issue of a warrant of commitment to prison. If you turn to paragraph 24,
yes,
Lord Justice Dyson expressly says, "We heard no argument as to the application of Article 6 to the civil methods of enforcement. What we say in this judgment is to be understood as applying only to the enforcement of a confiscation order by the issue of a warrant of commitment to prison." So I do query whether your last submission can possibly be correct, and that in some way or other what's said in paragraph 18 colours all enforcement proceedings.
Well, my respectful submission, the question that this court has to answer is whether these particular enforcement proceedings were in respect of an indictable offence, and that is a simple question of interpretation. I rely on what has been said by Lord Justice Dyson in Lloyd, simply for the purposes of highlighting the fact that they are part and parcel of the criminal process.
No, but he says expressly, I'm so sorry, he says it, have I misunderstood this? Please do say if I misunderstood. My understanding is he's expressly qualified that in the last paragraph of 24. He says nothing that he says in his judgment is to be understood as applying only to the enforcement of a confiscation. Sorry, that they heard no argument as to the application of Article 6 to the civil methods of enforcement, and their judgment is to be understood as applying only to the matters he's referred to. So my query is whether you can rely on this judgment for anything wider than he says in his last sentence in paragraph 24. It's really as simple as that.
I think I can rely on it for the purposes of making the very general point that, as a matter of just overview, that the enforcement proceedings are part and parcel of the criminal proceedings.
Very well.
I can't rely on it for the purposes of making any specific point that goes beyond that, for the reasons that the court has already identified.
Thank you. Anyway, ground 2.
So I now move on to ground 2. And of course this ground will only need to trouble the court if the court is with me on ground 1. And if I could just ask the court to turn to page 54 of the core bundle, you will find there Mrs. Justice Jefford's decision on this point.
Thank you.
48. Just give the court a moment to remind yourself of what Mr. Jefford said. My respectful submission, this turns on the interpretation of the word expenses in section 17(1) of the Act. So you'll find this on page 17 of the authorities bundle. And in my little submission, expenses there simply means expenses, it means exactly what it says. And that will generally include legal costs. It may also include other costs, but in my respectful submission, one of the biggest expenses that a prosecutor engaged in enforcement proceedings in either the High Court under the 1988 jurisdiction, or indeed even now under the 2002 jurisdiction in the Crown Court, the biggest potential expense that he or she may face is an adverse order for costs. My main point is that the word expenses is sufficiently wide to encompass that, in just the same way that, for example, when one has a trustee who is entitled to expenses, they may be entitled to recover adverse costs. And similarly, a litigation friend may be able to recover adverse costs from a befriended person or out of their estate if they are ordered to pay costs. I say exactly the same principle applies here. If I could ask the court just to turn to page 114 of the authorities bundle. Sorry, forgive me, I've made an incorrect note of the page number, but if you just give me 1 second, please. I'm going to be another 5 or 10 minutes or so, but unfortunately I seem to have made a mistake in recording the page numbers. I'm afraid I've just slightly lost my thread. I wondered perhaps we could, if perhaps we could conveniently rather keep the court waiting, we'll just rise 2 minutes early, and I will certainly finish by 1:10 this afternoon.
Yes, very well. That seems to be a convenient way of dealing with the matter. I'm sorry you're in difficulties there. So we will, well, why don't we say we'll reconvene again at just before 2 o'clock. So we'll reconvene again at 2 minutes to 2.
Madam, I'm grateful, thank you.
Thank you very much.